Welcome back to Publisher Group Talks. I'm Lauren and our studio guest is Muhammed Vally. Welcome, Muhammed.
Thanks, Lauren. I feel like furniture already.
I should say welcome back, because for listeners who's been tracking our show and following you, I'm sure they're dying to hear what you have to say today. And for those who are new and are listening to the channel for the first time or just tuned in, the aim of this channel is to create a platform that lives up to a motto of arrive smart, leave smarter. Educational, informative, inspirational. That's our motto. So, Muhammed, I'm just going to give the audience a bit of an overview as to who you are. Muhammed is a patent attorney for the past 8 years. He has degrees in both law and biochemistry. He practices in intellectual property rights establishment, commercialization and enforcement, as well as general litigation. He also practices in Rosebank, Johannesburg. Muhammed, today's topic we're looking at is trademark. Could you tell us what a trademark is?
Thanks, Lauren. Trademarks are, as we had previously discussed, a further form of intellectual property rights. I think one of the better definitions of what a trademark is can be summarized as follows. It's basically a mark, a graphical representation, whether words or letters or logos or a combination of these, that are used or proposed to be used by a person in relation to goods or services that their business offers in order to distinguish these goods and services from the same kinds of goods or services that is on offer by a competitor in the cause or connected in the cause of trade with any other person. So if one has to summarize it for the layperson, it's simply a signpost of origin. That is all it is. That's graphically depicted or through words that links that trademark to a business. That's all it is.
So it just protects that identification, like your Cell C, Woolworths, MTN. It's a link to that business.
Correct. So it can be the name. Woolworths can be utilized as a trademark in addition to the company name. But the letters W that appears in white, surrounded by a black block as background, that can be a trademark as well.
So you would actually register that color? Is that what you're saying?
In some instances you can. In most instances you may want to reconsider that position because it would be a limitation on the scope of the rights afforded to you. So if you're going to claim that color is a very important aspect of your trademark and somebody else goes and utilizes a similar logo, not exactly the same, but utilizes a different color, the mere fact that you've laid claim to that specific color may disentitle you to enforce your trademark against the person copying you. But there are other instances where color can play a very important role. For example, the telecoms operator in the UK, Orange, or in Europe, I think. That specific color of orange is part of its inherent identity. And in that instance, color would then be a very important thing to define.
So you could actually register the Pantone or the CMYK of that color?
As a characteristic of your overall trademark, yes, you can.
That's amazing. When does a logo become a trademark? Is there actually a point where there's a tipping point? Or how would you define that?
Well, I think one has to establish, first of all, what exactly is the trademark that you seek to protect. So, for example, you have a perfume product called Lauren, and you represent your trademark in certain ways. For example, you may have a specific font that you've designed yourself, or you've gotten someone to design it for you. I'm picturing something that's quite
ornate.
Correct. And you have it in a certain color, or maybe you just have it black against a clear bottle. That is how your mark is represented. So you may want to consider protecting the word mark if it's available as an extrinsic requirement for trademark registrability, assuming that nobody else has that trademark in a class specific for your particular product. The word mark would afford you the broadest form of protection. You do it in simple Arial font, irrespective of how Lauren may be depicted by anyone else. If somebody utilizes the lettering of the word Lauren in relation to a perfume product or something similar, then you may have a say on whether or not they have an entitlement to continue to do so. So that would define your broadest form of trademark protection, which would be an ideal. You want to go as broad as possible within the class of goods that you relying upon or depicting your trademark on, so that irrespective of color or stylized logo, you can bring an action for infringement to bear upon the shoulders of a competing business or a pirate for that matter. But in addition, you may also find benefit in protecting the stylized version, or maybe you've got certain design elements in association with the word. Maybe you've got some sort of circle or a little graphical design depiction or a pattern that you associate in relation to the word, and the composite mark is what you're after. And in that instance, it would be a good idea to possibly register all three forms. Firstly, the word mark. Secondly, the stylized depiction of the lettering. And thirdly, the composite mark, which includes elements of the logo, the graphical bit or your pattern. So it just depends on what is the most important feature of your trademark as appears to the notional customer.
And can I trademark my name? Well, you said I could trademark any name. How would I know what names I can trademark and what I can't trademark? Because you're saying I can trademark the name Lauren. What if someone else has trademarked that name Lauren, and what if they've done it in America?
Yeah. Look, trademarks, as are all intellectual property rights, are territorial in nature. So if you seek protection for any idea or trademark or design in a particular territory, those rights must be established in that territory. So if you want to enforce a patent in relation to your idea in South Africa, you must be able to do so from a statutory form of registration. You must have a patent registered in your name relating to the idea. In the same breath, you would obviously want to have a registration of that trademark in your name as well. You can action an infringement on the basis of a non-registered trademark, but like I said in our first program, the onus of proof is going to be the difficulty that you need to overcome. It would be better if you rely upon a registration, because then it takes away the onus of proof and it shifts that onus to the person who's copying you, for them to demonstrate why they've got an entitlement to utilize your trademark, irrespective of the fact that you've got registered rights. But coming back to your question, the first port of call, as has been a repeating theme in our previous discussions, is go to your attorney. Your attorney can give you good guidelines on whether or not there's intrinsic registrability requirements that have been met for purposes of the trademark itself. And the basic requirement here is that the trademark must be distinguishable. It must have an inherent distinctiveness. Sorry, that's the correct word. And if it doesn't, how do you acquire distinctiveness? You can acquire it through use. What do I mean by this? For example, fruit and veg city. These are, in truth, words that's required by the trade for purposes of selling their fruits and their vegetables. So you can't really go and acquire a monopoly in relation to those generic type of words. It's descriptive of the products that you would be selling. But if you've now represented your trademark in a certain way, whether as a stylized logo or part of a composite mark, and you've traded in the industry and you've acquired a reputation, now you've acquired distinctiveness, and you can then subsequently go and apply for a trademark. So on those two bases, if you've met the distinctiveness requirement amongst other requirements, then you should go and register your trademark. In relation to whether or not you're entitled to trademark your name, I would say yes and no. Yes, because it is something that you own, and by the same token, you're not the only Lauren around South Africa or the world. So somebody else who owns the name or has the name Lauren can also potentially apply for a trademark, depending on which class of goods or services they want to apply in, but also depending on what else is there on the register. If somebody else has, a day before you, gone and filed a trademark in the appropriate class, if somebody goes and applies for a trademark in relation to the category of goods or services that you have an interest in, they have the prior right, and they could exclude your registration as well. There are instances where you can apply for registration of the mark nonetheless, but that's for a later discussion. But I'll mention it as an honest concurrent user. If you've been utilizing the mark and there's been no objection, you've acquired a reputation in the market, then you ought to succeed in an application for registration. Now, unlike in the domain of patents, where an application for a patent is not going to be considered substantively on the merits by the Registrar of Patents in South Africa simply because we don't have the facility to do so. There's plans to acquire some sort of substantive examination to operate in the future. The Registrar of Trademarks functions as an examining office. So if there are prior rights that exist, the Registrar could raise the existence of those rights against your registration as a bar. So you wouldn't automatically acquire that right. It depends on the facts of the case. But as a point of departure, yes, if you've got a trademark that isn't excluded by somebody else's prior existing rights, yes, you can register a trademark in relation to your perfume product.
Will registering my name or my business name as a trademark benefit me in helping getting a domain name? So if I find somebody else using that, can I go and send them an email and say, please note, this actually belongs to me, you're using my name?
Yeah, that's a question of fact. Now, domain names, notoriously difficult territory.
Very.
Lots of people register domain names as cyber squatters, or simply they reserve the domain name for later use.
Yeah, lots of people do that.
Correct. Whether that use is to subsequently sell the domain name at an inflated price, or that they've actually got a genuine intention to utilize that domain name for purposes of their business. I consider domain names as part of a type of intellectual property right. So when you are considering filing for a trademark in relation to a certain mark, you should also at the same time consider registering a domain name directed to that mark, simply to avoid confusion later in the eyes of the likely customer. It's important that your social media accounts are also registered because we live in an information era. People have smartphones, and the first thing they're going to look at when they're looking for someone is possibly through Facebook or through Instagram. You want to have the opportunity to reserve your name there before you go and you create a get-up, before you go and market your product and your business, spend a lot of money only to come to understand that somebody else got a domain name. Now, your question was whether or not you're entitled to, subsequent to your registration of your trademark, to ask somebody else to give up that domain name. And the answer is it depends. It's a matter of fact. If the domain was registered prior to your trademark application or your trademark registration, as the case might be, and this person has utilized that trademark or the domain as a trademark in the connection of cause of trade, then arguably they've got prior use rights, which may disentitle you to your registration of your trademark. But if they've simply gone and reserved the domain, then I think you've got a bit of a case to go and fight, to say, you're not utilizing the domain. I've applied for the registration of a mark, and it also depends on the extent of utilization of that mark in relation to your business. If you're just starting out and you don't have any presence on the market, then I think it's going to be a difficult matter. But if you have a presence on the market, a local presence, and you can demonstrate that you've got a reputation that you've built up in relation to these products, then yes, you've got a case and you can ask them, give it up. There's a mechanism that's available to South Africans through the South African Institute of Intellectual Property Law, where there's an ADR committee that deals with domain name disputes, and you can refer your dispute to that committee for adjudication. Depending on the merits, you could be successful, or perhaps they might dismiss your application, and it all depends on the facts.
And that would be a .coza or .com as well?
For both. If there's any other top-level domains, perhaps you've got a .mx or anything else, you've got the opportunity to go to an international adjudication body. But remember, because it's an alternative dispute resolution mechanism, ADR, you're going to have to pay for those adjudicators to consider your matter. Now, the benefit is that you could get to a resolution much quicker compared to approaching the courts, because you can then self-regulate how those proceedings are going to continue. But at the same time, it could be expensive. But litigation is expensive anyway. It would be a good idea for you to consider these alternatives. There's an international move to harmonize the requirement to seek alternative dispute resolutions, something you can consider.
One of our listeners had emailed through a question about a week or two ago, and they were asking, they've had clients in the past where they've designed logos for those clients, and the clients have said to them, do you mind just adding a little TM at the end of that logo, or make sure that it's there? The designer knows that the logo is not trademarked because they've had to design it, and the client just says, oh, just put it on.
Right.
What do we do in a situation like? I thought it was a great question.
No, it's a great question. It's a very relevant question. It comes back to the differences between a registered trademark and a non-registered trademark. If you wish to rely on what is known as common law rights in and to your unregistered trademark, you're more than entitled to utilize the letters TM in superscript adjacent the mark that you intend protecting. It is only where you have a registered trademark that you can utilize the symbol R within a circle to indicate to the general public that this is a registered mark. Until such time as you hold a registration, it's actually a criminal offense to utilize that symbol.
So stay away from that little R.
Unless you have a certificate, yes, stay very far away from it. But look, we haven't seen much, or at least in my experience, of criminal complaints in relation to that use. But you want to avoid it. You want to utilize the appropriate mechanism for the establishment and subsequent enforcement of your rights.
So is the designer who's then asked to put the R on the logo and they know there's no certificate, are they committing a crime?
No, because the letters TM would actually indicate a reliance on common law trademark rights, which doesn't require preceding registration or application for registration. But if the designer knows for certain that the instruction to put an R in a circle to indicate the existence of a registered trademark shouldn't be there, then arguably speaking, the designer could be aiding and abetting the primary infringer or the primary person committing the crime. Yes, so they could get in trouble.
It's good to know that, because you don't want to say often put in that position, but you can land up in a position like that, and you need to be very careful. So it's important to know where those boundaries are.
And it's good that you mentioned this, because another question that may come about as a result of this inquiry is there any obligation on any person who's performing a service on behalf of somebody else to ensure that there's intellectual property right non-infringement or infringement for that matter, and what to do in those instances? I don't think that there's a legal onus on anyone who's performing a service on behalf of somebody else to ensure that the person who's requesting the services be conducted is compliant from an intellectual property law perspective, perhaps a moral one. But that doesn't open you up to litigation or claim. One way to avoid any nasty surprises is to, in your terms and conditions, your T's and C's, upfront include a clause that abdicates all responsibility from your account and places it on the shoulders of the person who's giving you the instruction.
Yes, that I, the company or designer, am in no way liable
for any third-party infringement of rights, including or more especially intellectual property rights, and an indemnification that if in the instance there is an infringement that was perpetrated by virtue of the designer continuing to do what he was instructed to do, then at least the designer can raise it as a defense against a claim for infringement, and rather not participate in that quagmire, that dispute, and leave it for the parties who are in fact responsible for bringing about the dispute in the first place to answer to the courts and to the holder of the rights.
Another listener had asked about putting, which I think also this kind of ties very nicely in, is putting the South African flag on a logo. So making a product for a client, like as we had said, tomato sauce, jam or chutney, and then the client saying, can you just put the South African logo on the corner and say made in South Africa? And you don't even think that would be illegal? Is it allowed?
Yeah, look, as a badge of origin, generally you can put a South African flag on a product to show that it was manufactured in South Africa. The provisions of the Heraldry Act may apply, so in certain instances you may require permission. But if you want to specifically use the South African flag colors in relation to a tick and the words proudly South African, there's a public functionary that deals with that sort of thing. And I think it's just a written permission thing that you need to get from them. to
Okay.
indicate that your product is manufactured in South Africa. They're obviously going to have certain requirements for you to utilize that in relation to your product. So the one basic requirement is that the product must be manufactured in South Africa. And you might be in breach of your contractual obligations owed to Proudly South Africa if you're manufacturing in China and selling in Namibia, claiming that it's from South Africa.
That could be a problem, yeah. Yeah, that's very interesting. So would you be allowed to go around and tell everybody that you're proudly South African? You're not going to wear a t-shirt with a tick, but are we allowed to actually say that? Or is the actual word spoken owned by someone too?
Yeah, the Proudly South African logo and the payoff line, Proudly South African, in association with the logo, that is owned by an entity known as Proudly South African. And you would require their consent to place that logo and payoff line onto your product. And it depends on their requirements. I know the main requirement is that it must be local manufacture, you must utilize local resources and basically stimulate the local economy. But the principle is exactly the same as you wanting to utilize somebody else's trademark that is either registered or unregistered. And that is one of license. So if you want to utilize a trademark, say, belonging to McDonald's for whatever reason, you know, the arching M symbol, and they prepared to permit you to do so, you can enter into a license arrangement with them for purposes of representing that trademark on your goods or services. I know it's a bit of a weird example, but the principle applies the same in relation to anyone who may be the holder of a right. And if one looks at it from a different perspective, you as the holder of a trademark right, if you want to utilize your trademark for a particular purpose and somebody else wants to utilize it for a different purpose, you've got an option. You can either permit them under a coexistence agreement to continue doing as they're doing with a trademark that may be the same or similar to yours, or you can license out the use of their trademark and earn a royalty off their endeavor as well. It's a passive form of income, but it comes down to the broader principle of licensing under the rubric of IPRs, is that you're a South African company or an individual sitting here in South Africa and you're entering into the local market with a particular product under a particular brand name for whatever unique selling point that you may want to exploit. It doesn't necessarily mean that you have the ability to feature that product or that trademark in relation to the product in the UK or the US for that matter. Foreign markets are always an untapped potential that people aspire to in businesses. You want to export your product because there's many benefits that the DTI offers to a South African entrepreneur for purposes of building up their business. And it's a difficulty for the local South African notional company or individual to expend time and resources in establishing that company in those different countries. So for that reason, based on the territoriality principle that we spoke about, you may wish to acquire trademark registrations or patent registrations in different countries where your intended market may lay. Some people want to know, how do I get a worldwide patent or a worldwide trademark? It doesn't exist. There are certain mechanisms that permit you to file for these rights in a more efficient way as opposed to going into each individual country, but the obligation remains on your shoulders as the holder or the potential proprietor of the mark or the IPR in that country to file an application in that country and to acquire the rights upon registration. Once those rights have registered, you've now got the tools to approach a licensee, typically who's got local knowledge and local supply chain know-how, who can take your product, stick it into their machinery and start featuring these products on different shelves on the shop fronts. But how do you protect yourself against the exploits of somebody you don't know in a different country, where if things go south, you may have to litigate in that country, which could be severely cost prohibitive, even for a large company in South Africa? You want to ensure that you've got the first means of protection, and that is the registration of those rights. Then you go to a negotiation table and you are able to tell your intended or your potential licensee, I have the monopoly in relation to this product by virtue of the existence of my patent rights, or the brand name that I've built up in South Africa or maybe even Southern Africa, which has a reputation. and people perhaps in the UK have seen this product and they want to acquire the product locally there in the UK, you can then say, I hold the trademark rights in and to this trademark. And I can then license to you, to the exclusion of everyone else within that territory, the use of this right. And in doing so, you're creating an antecedent to a conversation where you can negotiate on better terms as a licensee, as opposed to going there and simply competing on the open market with anyone else. And as life would have it, if your product is successful, you can expect pirates and people who copy you or your product to come about in large number. You don't want to be caught flat-footed without the tools available at either your disposal or the disposal of your licensee to be able to quickly and efficiently approach the courts for an interdict to stop that copying or that infringement. So these are business tools, apart from the business psychology we mentioned in an earlier show, that you can utilize for purposes of extracting the maximum potential derivable from a revenue that you ultimately want to obtain for purposes of your business.
It's very interesting. It gives the listeners quite a lot to think about in what you're saying, and it also helps them kind of gather an understanding of when they actually should, when it's worth registering that trademark, when it's also worth considering that their intellectual property is worth registering.
It certainly is. I think I mentioned earlier, it's damned if you do and damned if you don't. Let's talk about the damned if you don't. If you don't register, whether it's a patent or a trademark or anything else, you're basically introducing a vulnerability into your business to permit others from copying. And then it's a very difficult task for you to go and interdict that person. On what basis are you going to go if your idea or your invention hasn't been the subject of a patent registration? It has fallen into the public domain. How do you then go about and say, you're competing with me unlawfully, I need to interdict you? Patent rights and all other IP rights are known as rights in rem, meaning that these rights are almost as comprehensive as the right to ownership. And I'll give you an example. If I am the owner of a certain motor vehicle, I have the right to that motor vehicle and to do as I please to that motor vehicle to the exclusion of everyone else in the world. The basis of the territoriality principle that I mentioned earlier in relation to IPRs, that means that your right in rem in the IPR is to the exclusion of everyone else where the right is established. So if you've established the right in the Republic, you are the person that can utilize that right to the exclusion of everyone else. So it's a very strong right to have as part of a repository of rights in and to your business that you can negotiate and engage in a commercial sense with not only your competitors or your customers, but more importantly, your licensees, people that you want to strategically partner up with because they can bring certain benefits to you, you bring certain benefits to their table as well. But you negotiate from a position of, in a sense, power, because you have the ability to tell them this product can legally only be sold by you. As opposed to you're going to compete on the open market with 10 other companies who's likely going to start selling the same product, and then it's a matter of price competition and all
trying
of
to
that
prove
nonsense.
that yours is better than theirs, and
Correct.
almost slating them in some instances indirectly. You know, as many competitors do. They could sort of put a tongue-in-cheek play on it, which is indirect, and try and market it theirs is better because...
Yeah. Like motor vehicle spare parts, for that instance. Some people would say it's BMW suitable. In the meantime, it has nothing to do with BMW except that it's a copy. You don't know anything about the material, you don't know anything about the quality, and it could arguably be the type of product that is inferior to that which you're selling. And if that is the case, and people confuse that product with your product, it could actually harm your business reputation. People would say, Lauren's perfume product doesn't last for 2 hours, it's a piece of crap. I'm going to go and buy the next best product. And it wasn't even your product in the first place. Somebody simply adopted your mark or your reputation or your get-up or your logo, and they've passed it off as that of yours, or that you have some sort of association. So the damned if you don't holds a lot of negative
tricky.
potential consequences.
It's like you can't just sew your label into anything. just to put a price on it. It's the same thing.
Correct.
Just because you've got a whole lot of spare labels that you bought in Chinatown, you can't sew it onto your suit and now it's Armani.
Correct.
That's always a
Precisely the point.
very, very tricky, hey?
Precisely the point.
Yeah.
So, in addition to your licensing arrangement, you can also regulate the type of quality of the products that your licensee is going to put on that market. And you can have a say in the projection of your image that you've now worked so hard and fast for in South Africa in these other countries. So the establishment of rights in countries specific for your intended markets is a very serious business decision that you need to carefully consider. If you're going to throw millions and millions of rands to the creation of these rights in every single country in the world, or at least the bulk of it, you might be throwing money down the tubes because you want to establish rights in markets that you may not ultimately enter into. So choose your markets carefully. If you're just going to Pakistan and London, confine your registrations to those two particular places. Otherwise, you're going to be spending money that could otherwise be dedicated for marketing purposes and for deriving the best benefit in those jurisdictions to feed your business in South Africa.
That's really interesting. Thank you. Is there anything you'd like to say in closing to the listeners?
Yes, I think there's a notion out there, and it may not be far-fetched, but there's this notion that, attorneys are so expensive. Should I go or shouldn't I go? I'd rather not go. I'll try and Google, learn the processes myself. There's an old saying, this was told to me by Derek Harms, a senior counsel who does IP litigation in South Africa, that a client, a litigant who has himself for a lawyer, has a fool for a lawyer, something to that effect. But you'd rather go to an expert. Get the right advice from the get-go and make sure that the vulnerabilities that could otherwise be introduced into your business, whether intentionally or unintentionally, are minimized. You're always going to have a stumbling block. You're always going to have a challenge in your business. By establishing these rights through the correct mechanism, you are potentially reducing the risk for later invalidation or for somebody simply competing against you in an equal footing in circumstances where you could have offered a monopoly to your business or to your licensees or to your business partners. So it's like insurance. It's a grudge purchase.
It is.
But go and purchase.
But it's also tax deductible.
Correct. There are some tax benefits for the creation of IPRs. That can be the subject of a different discussion. But just remember, if you want to have that tax benefit, go and consult with your tax advisor upfront.
Exactly.
You need to have approval before you start spending money on the R&D initiative. But it's a good thing to have. Yes.
It is. Thank you so much, Muhammed. Listeners, connect with Muhammed on LinkedIn. You can also email him. You'll find all the relevant contact details on our network channels. And please let us know what you think. Send us comments and questions and we'll feature it on the show. The email you can get hold of us on is hello@publishitgroup.com. And tell us what you think. We always say negativity is good as long as it's constructive. So come with a solution. Tell us what you want to hear or ask your questions and let us open it up. Let us look at it. And if you've got something interesting to share, you're welcome to come on the show. Thank you so much.
Thank you, Lauren, and thank you to the listeners.
See you guys soon.